This meeting is being recorded.
Hello, this is a pre-recorded webinar for the Tamworth Family Law Pathways Network. This webinar aims to be a resource both for professionals and services working within the family law sector and for parties to family law proceedings or those contemplating proceedings within the Tamworth region. It will provide an outline of self-representation in the family law court system and answer some of the common questions posed around unrepresented litigants. We are delighted today to be joined by two panellists. Firstly, the Honourable Janet Terry. The Honourable Janet Terry was a barrister and solicitor from 1977 until 2007, when she was appointed a federal magistrate. She sat in that role in Darwin until July 2010, when she transferred to Newcastle, and in 2013 was appointed as a judge of the Federal Circuit Court in Newcastle. In 2021, having reached the mandatory retirement age for judges, Judge Terry retired and is currently enjoying her time away from the bench. Welcome, Judge.
Yes, thank you. Very much enjoying my time away from the bench.
And secondly, Joanna Birtles. Joanna is the owner and principal solicitor of Parting Ways Law, a law firm with a different model to a traditional full-service firm, as it instead offers a coaching service where a family law client is coached to represent themselves, to do as much of the work as possible as they can, and then specifies the work that they want their lawyer to perform. Joanna achieved her law degree in 2012, and in addition to work as a family law coach and solicitor, has worked as a mediator in family law matters and as a deputy associate in the Federal Circuit Court. Welcome, Joanna.
Thank you for having me here.
Joanna, a question for you to begin. Is it even possible for someone to represent themselves in court in a family law matter? And if they were going to do that, how do they go about educating themselves on what to do and what resources are available to assist them?
Look, yes, to answer the first question, yes, it is entirely possible for someone to represent themselves in the family law process. But I guess the most important thing is getting the right information from the right sources. There is an absolutely overwhelming amount of information out there for people going to self-represent. All you have to do is enter how to file for divorce, how to do an affidavit into Google or any of the other search engines, and up pops a overwhelming amount of information for people. So usually the best place to start for some resources is the Federal Circuit Court and Family Court of Australia website. The new website, very clean, very user-friendly, and it talks about how to fill out all the forms, which forms you need to submit. It's even got some great videos on the website now as well. So that's a really great resource to start with. As I mentioned also, you've got your search engines such as Google. You can plug some information into there and up pops all these resources. But how do you know exactly which one is correct? You've got, these days, lawyers all have on their websites, most lawyers have blogs now on their website. So plenty of information out there. However, I guess the self-represented litigants need to be mindful of what a blog actually is there for. It gives you a bit of a teaser information, and then there's a call to action, which is, here's a little bit, book with us to get the whole information. So you can get a little bit of information from blogs. You've also got social media out there, but you've got to be very careful with the information that is on social media. There's all these groups out there that you can request information from. However, I've been watching a bit of these groups over the last few years, and usually a request for information can be met with some really great helpful information for the person requesting it, but also some not so helpful information and also some heated arguments, which ends up leaving the person who's asked the information more lost than they initially were. So you have to be mindful of those sort of social media platforms. So there are firms out there now, such as our firm, who offer what's called these unbundling services, where the clients get to pick and choose what services they want the lawyers to represent. We also offer plenty of information on the websites, and also the clients can book in for strategy sessions, which is just getting ready for court, things like that. So there are a few other firms out there that are offering these resources.
Interesting. So with strategy sessions, you and other firms that do this kind of work are coaching people on what they need to do when they themselves appear in court.
Yes, in essence. So it depends on what they're actually after. So if they have a court mention coming up, for example, firms like ours, they can book in for these sessions, go through what the actual court appearance is. Is it a mention? Is it the first appearance? How to get ready for it? What documents to have ready for it? And even things such as what side of the bar table they need to stand at when they enter the courtroom, what to do, what to wear, what to say, how not to say too much, those kind of things. So we can offer clients with those kind of services.
Okay, thank you. And Joanna, you mentioned that the first resource that clients might consult would be the Federal Circuit and Family Court of Australia website. Just for anybody watching, for their benefit, that a website address is www.fcfcoa.gov.au. And a good tip there for the most reputable place to go for information is the government website with that published information. And then to treat other resources that pop up in Google just with an air of hesitation before accepting the suggestions that they make. Thank you. And Judge, a question for you is, what is the role of the court when somebody appears unrepresented before you?
The role of the court is the same in that case as it is in every case. The court has a dispute before it. It's got an obligation to the parties to assist them to resolve the dispute as speedily as possible and in a fair way. And that may involve the court diverting the parties out to mediation or to a court event which is going to assist them to try to resolve the matter. If the matter doesn't resolve through mediation or conciliation, then it goes to trial. And the court's obligation is to make sure that parties have a fair trial and that both sides have an equal opportunity to be heard and to present their evidence. And then the court has to deliver a decision based on the evidence. So that applies regardless of whether you're self-represented or representing yourself or not. But when one party is representing themselves, the court does face particular challenges. And I want to say at the outset that there are some people who come to the court unrepresented that people like Joanna and the court can't help. And in fact, in those circumstances, it's actually the represented party that needs help. So you have self-represented people who come to court and they're very angry. They might have been family violence perpetrators, but for whatever reason, they're very angry. Sometimes they're simply angry that the other party's ended the relationship. They might have alcohol problems. That's one of the biggest hurdles, in my view, in trying to resolve matters because they're often in denial about the extent of their problems. They might have mental health issues. I'll come to that in a minute. They might have drug use issues, which means they're erratic in attending court. Sometimes they turn up and sometimes they don't, and they don't comply with orders. They might have mental health issues that are not bad enough for them to be entitled to a litigation guardian, but are bad enough to cause enormous problems in the court system. And I'm thinking in terms of perhaps someone who's got a personality disorder. I mean, a judicial officer can't diagnose these things, but so often people come across as if they've got narcissistic personality disorder. They're right, no, they won't listen to anybody else. So those people can cause enormous problems in the court system, and there's nothing the court can do to help them because they're not willing to listen. They're often abusive and rude. They intimidate their partner in court. They might be abusive to the bench, which the bench can deal with. They're also often abusive to the other lawyer. They won't listen. They don't care what other people think the law is. They know better. They don't care what other people think their problems are. They don't think they've got any. So sending those people out to mediation is not going to help. And if they're angry, they might be the kind of person who absolutely delights in making life difficult for the other party. They might not comply with orders, bring applications that are useless, that can't succeed. They try to delay the matter being resolved. So in those cases, if the court identifies that as the problem with the unrepresented litigant, fairness to the whole system requires that the matter be moved as quickly as possible to a trial. There's no point trying to help that range of people. They're not going to listen to you. They can't be helped in the court system. And you've really got to do what you can to protect and help the represented party. But there are a lot of other types of people out there who self-represent. And there are a number of people, and I've seen this on many, many occasions, who genuinely can't afford to pay for a lawyer. I mean, a lot of people don't have tens and tens of thousands of dollars to pay for a lawyer. I used to feel very sorry for people when a matter came before me, and I had a couple of these where they were still paying their lawyer for their last court case, and then they were back in court again. Other people think they know best because they look at the size of the dispute, they look at what it's going to cost them to have a lawyer, and they decide that on a cost-benefit basis, they'll represent themselves. So those people, the court can and must, if you like, assist to ensure that they get a fair go in the court system. They'll be referred out to mediation and conciliation as well. But experience suggests that their lack of knowledge of the law might mean that that doesn't work and the matter has to go to trial. If the matter goes to trial, then the court's got an obligation to the self-represented person, to both parties, but particularly the self-represented person, to make sure they have a fair trial. There's a very old case called Re F. Lawyers will know this, but it's called Re F, Litigants in Person Guidelines, and it was considered in the case of Johnson and Johnson. And I'm not going to worry about giving you a citation now. You could look that up to give to people. But it sets out 9 things that a court needs to do when it's got a self-represented litigant in front of it. It needs to ensure the proceedings are fair to both sides, has to inform the self-represented litigant about the way the trial's going to proceed, has to explain procedures. It might need to step in, it might need to introduce witnesses, it might need to remind a self-represented litigant that they can object to evidence. It might need to help them in terms of their submissions to the court. So the court will have to go a little bit further and do some extra things if one of the parties is unrepresented. It has to be very careful though, because the represented party's barrister is going to be listening very carefully to make sure there's no sign of bias. But the court does have those obligations, so it will do everything it can to try and make the procedure fair for the self-represented litigant. So that is the court's obligation, but there are difficulties for self-represented litigants that the court cannot overcome. It cannot overcome them, and that goes back to what Joanna was saying about people being able to get some advice. One of the things the court can't do is make sure that the unrepresented party actually understands the law. People learn a trade often. They learn a trade, they learn how to fix a car, they learn how to fix a fridge, they become a plumber, they know how to do fencing. Lawyers learn the law. You can pick up a statute, the Family Law Act, and you can read it. But the words on paper might mean something to you if you haven't done legal training. and something entirely different to the court and to the represented party on the other side. If you pick up the Family Law Act and have a look at section 79, it talks about the steps that are taken to sort out a property matter. There is no mention in there of working out, setting percentages for contributions. There's no mention in section 75 of setting percentages for section 75(2) matters. But when people go to mediation or go to trial or try to negotiate with the other side, that's all that will be talked about. So they're up against that sort of difficulty. Section 143 of the Child Support Assessment Act says you can get lump sum maintenance. It very clearly says it. Well, you actually can't in the way that it says it, because years ago, the full court read that section down to make it fit with other sections of the Act. The best interest factors about children might seem simple. And at the beginning of a trial with a self-represented litigant, we always used to hand that out to them so they could read the best interest factors and know how a court was, what a court was likely to do in terms of determining the matter. But there is an enormous body of law behind those factors that the self-represented litigant won't be aware of, that make a difference about how the court applies them. Even words can trip them up. The word abuse means one thing in the Family Law Act, it's defined. But out there in the community with their mates in the pub or their mum around the kitchen table or their partner, the word means something entirely different. So a self-represented litigant who goes to court and runs their own case in a family law matter is disadvantaged because of that lack of knowledge of the law, and there's nothing the court can do to level that playing field up, nothing. And that comes back to what Joanna was saying, that at the very least, people should be going and getting some basic legal advice. Because if they don't, there's a diminished prospect of the matter settling, which is actually, again, unfair to the represented litigant. The mediator or the conciliator is going to have an awfully hard job trying to persuade the person to settle the matter. So is the other lawyer. So the court does everything it can to help people, but there are some difficulties that it cannot overcome. So that's a lengthy answer to your question.
Well, Judge, there are a few nutshell summaries I can say is that unrepresented litigants don't know what they don't know, and that can be a very hazardous trap for them to enter into. If they read the legislation and think that they have understood it, little do they know that there is a huge difference between the written law and the living law. An analogy I often think of is that if you envisage a frame of a house and the foundations, that's the legislation. It's in writing, but it's lifeless without walls and furnishings and window coverings. And the case law that lawyers learn at university and through their careers are the walls and furnishings that really flesh out what the state of the living law is. And it can be so difficult for people to walk into a courtroom without training and know what they're saying unless they've had some enlightenment as to what the state of the living law is really like. And so back to Joanna's comment that she'll meet with people to try to coach them in a brief period of time into what the really pertinent aspects of that living law are for their particular moment in court. But that might only be just for that appearance. It might not be enough to see them through to a trial.
And that's putting it extremely well in terms of people's lack of knowledge of the law. That's really well put.
Well, thank you, Judge. And certainly you highlighted some difficulties for the court there, because there is such a fine line, I imagine, for a judge to guide an unrepresented litigant to the correct procedural matters as they're required to do, but not to give them legal advice and tip off the other side that there might be a hint of bias toward the unrepresented litigant's favour. So how do judges handle that really tricky line, balancing it correctly?
You just do the best you can, and you're always very careful, and you're always thinking about, you hardly ever say anything without thinking before you say it, because you can be appealed or you can have a vociferous objection from the other side. So you do have to be very careful with your words. Sometimes you find that people ask for you to disqualify yourself. Not too many people go on appeal seeking that after a hearing with a self-represented litigant, but I've known cases where a judge might sit there and think I've gone too far, and they might ask a colleague to take over the case. So it's a very difficult line. You do the best you can. You think before you talk. That's all you can do.
Thank you, Judge. And as you think that there is a great cost to some people who do engage lawyers, Joanna, a question for you is, we know that some litigants qualify for legal aid, and they're typically down the lower end of the earnings scale because there's a means test to be eligible for legal aid in New South Wales. And then at the other end of the earnings scale, we have the wealthy or those who have access to some funds to be able to pay lawyers in your traditional sense in a legal matter. But then there is a vast number of people in the middle who neither qualify for legal aid nor can afford a lawyer. So questions for you, Joanna. What are some of the financial considerations that people need to consider when they're deciding whether they should self-represent or not?
Yes, it is an interesting one, and you touched on the legal aid is very much there's a means test, and it's quite a low means test as well, so not many people are eligible for that. But there's also the other consideration of lack of, I guess, legal practitioners who are offering legal aid work as well, in particularly in rural areas. And then, yes, you do have the higher earning people who can afford to throw thousands and thousands of dollars at their matter. But what you see is so many, and what I saw is so many people falling through the gaps and not being eligible for legal aid and not being able to afford a solicitor to appear for them all the time. And plenty of people coming and saying, I just need help with documents. I can't afford to pay you for everything. And so that's why the firms like myself exist with the unbundling services, which are fixed fees. So the clients are able to see how much it's going to cost them, and they can actually have an idea of how much it may cost them along the journey of the court process, rather than being stuck with invoices after a month or after a few years and having to keep paying off. And Judge touched on that, was that often parties are still paying off the legal practitioners from their first case, and then they end up in court. I've seen that plenty of times where they get their final orders, but then they have to go back to court. There's contraventions, there's enforcement. Someone tries to reopen the case. It's often never ending for some litigants, which is really unfortunate, but that's the reality. So when, I guess, to go back to your question of what would people consider is, I guess, the length of time it could take. It's not, people think, oh, it's one court case, one court day, it's all going to be done and dusted. It's not like that. There's lots of times that the lawyers will have to turn up. There's lots of work, but also how complex is the case? Is your lawyer going to need to do a lot of work? Are there going to need to be a lot of subpoenas issued, a lot of financial disclosure to go through? Those costs can start adding up. The more work you get your solicitor to do, the costs will add up. Every phone call you give, you make, it'll be more costs. So the ability to have people able to get some access to some advice, access to assistance with court documents, access to things like preparing for a mediation or conciliation, and being able to do it yourself, that's what these unbundling services are for those people who have been falling through the cracks and not being able to access assistance. So I guess, yeah, that's what you might want to, what people need to consider is whether, like, the extent of time and the amount of money, and it may not end after that first case. You may still be paying off solicitors after that.
Right. So often parties might say, I'll just engage a solicitor to do this interim application for me, not realising that then the matter will progress and sometimes for many years, and then need to come up with those funds. So what some lawyers are doing now is trying to figure out some sort of middle ground service for people who can't afford those traditional legal fees.
Yeah, exactly. Just because it comes back to, I guess, the original question that you asked me, which was education and the resources. It's trying to educate people on what the system and the process of entering the family law system is like, how long it could take. It's not just like a criminal case where you rock up, you plead, and you may get sentenced within a week or a month or something. There's a lot lengthy cases, and there's a lot that goes behind it. I guess another thing for people to consider is when you engage a solicitor, yes, it is costly. However, so much work goes on behind the scenes that these legal practitioners have to do, and I guess people don't understand the amount of work. They don't see the work that goes into it behind the scenes. They just see the cost. So people always hear these horror stories of how much they've been charged, but on the other hand, that legal practitioner has put in a lot of time and effort into that most of the time.
And no doubt lawyers are required to warn their clients about the kinds of costs that they will incur, and that every phone call comes with a cost. Now, this judge, a question for you about sort of your experience with some of the cost applications that might have come before you is, I've heard of a few different means for people to fund legal representation in their family law matters. For example, there are litigation lenders out there who lend money to people and then request that it be repaid with a significant amount of interest. A lot of lawyers require that money be paid upfront into their trust account before they'll start working on a case, just so that they're confident that the clients will be able to pay their bill. And also people borrowing money from family and banks wherever they can in order to fund representation in matters that are so very important to them, such as their homes and their children. But Judge, in your experience, the majority of cases, the outcome in relation to legal fees is that each party is to pay their own costs in a family law matter, and what that means. And I'm also interested, Judge, in hearing your observations or any recollections you have of the gravity of legal fees that have come before you.
I've had some cases where the legal fees have caused me personal distress. I had one case that involved a few $100,000 worth of property, and between them, the parties had spent $200,000. And I've had several of those. So legal costs can actually be horrific, and it's easy to remember those horror stories and to find those horror stories. But perhaps an aspect of this that needs to be considered is the issue of the fact that the self-represented litigant may avoid costs by not engaging a lawyer, but they may incur costs in other ways. And one of them, as you've just touched on, is that they may have a costs order made against them. It's a particular danger in a property matter because people can put in offers of settlement. And if the outcome for the person who puts in the offer is better than what they were proposing, they can seek costs against the other party. And those costs can be huge. I mean, tens of thousands of dollars. So the self-represented litigant might think they're not paying anything, but they might end up paying the other party's legal costs or part of them, because their lack of knowledge of the law means that they haven't settled the case when they should have. If they run a child support case, certain types of child support case, and they lose, there's a provision in the Act that costs follow the event, as in civil litigation. So if you lose, you pay the costs. In family law matters, costs normally don't follow the event. So normally each party bears their own costs. But there are circumstances in which costs can be awarded. One of them is the property kind of matter that I've just mentioned. But costs can be also awarded in a children's matter. If people bring unreasonable applications, say it's a second application to get particular amounts of time with the child or to change residence, and the view is formed that that was unreasonable, then a costs order can be made against people in parenting matters as well. The other thing that they often forget is they might end up getting an order to pay the costs of the independent children's lawyer if the matter runs to trial. So it might be that they should have settled their parenting matter. They didn't. It runs to a 4-day trial and the Legal Aid Commission hands them a bill and the court orders they pay that. So a self-represented litigant doesn't necessarily escape costs. So, but just to perhaps to get back to touch on a couple of things Joanna said about the unbundled legal services, they're certainly good and they're better than nothing for the self-represented litigant. My hat goes off to the solicitors who are willing to offer them, because there are certain risks for solicitors, to be frank, in going down that path. So if people are willing to offer that service, more praise to them. But it's not ideal because people don't, the solicitor isn't involved in the matter throughout. They often don't go to court with the party and actually see the other party, hear some of the evidence and get a different feel for the case, a different feel to what they might get when someone's sitting opposite them. So the advice they can offer can be fairly limited. So it's better than nothing, but it's not ideal. Perhaps I would just say that if people are going to spend money on unbundled legal services, in my view, one of the most important things they can spend money on is getting help drafting their affidavits, because that's where a self-represented litigant often falls down. They'll put in a very brief affidavit, or they'll put in an affidavit that's full of scurrilous and vexatious things, or it'll have objectionable things in it, such as what the neighbour told them their wife was getting up to when they were at work, and they'll sit there and watch all this get struck out. Or they won't bring evidence that they should bring. In a property case, for example, there's nothing you can do to help a person if they fail to bring certain types of evidence. They might fail to put their mother on affidavit to prove that she loaned them $200,000. They might fail to bring other evidence about the value of assets. You can't help people when they come to court with an ill-prepared case like that. So if there's one area I would suggest, apart from getting a good idea of the law if they can, where they get help, it's in drafting the affidavits.
Thank you, Judge. That's a really helpful tip for people watching this. I've always taken the approach with affidavits that they need to contain factual matters only, those matters that can be proven very easily. They're statements of facts. They don't contain speculation or emotion. Now, it's not to say that litigants won't have a chance to get that evidence out at some point during their case, but it's not to go into an affidavit because, as you've just said, Judge, that will be struck out, meaning that the judge will take a big fat black texter and text it over all of those comments that don't fit within the scope of what an affidavit is supposed to be. Is that correct, Judge?
That's absolutely correct. And it's very demoralising for people at the start of a trial if half of their affidavit is struck out before they even start. And the last thing they need is to be demoralised at the beginning. Plus, that's another area where they can end up having a costs application made and may have a costs order made against them.
Thank you. Well, that leads into my next question for you, Judge, which is, how can self-representing go wrong? What are some of the common missteps and mistakes that you've seen before you in your courtroom?
The most common way that it can go wrong is, as I said, in a property matter where they just fail to bring essential evidence and there's nothing the court can do to help them. But even in a parenting matter that can happen. For instance, they might talk in detail about an event at which the other party did something terrible and the other party will totally deny that it happened. And then the unrepresented party will say, yes, but X was there. They could tell you this, but they don't bring them to court. So that corroborating evidence simply isn't there. And you're very unlikely to get an adjournment so that you can go out and get your best mate or the other party's ex-partner or whatever and get them to come to court and give that evidence. So failing to give evidence to the court is a major problem for people who are unrepresented. And again, as I said, it's a problem you can't fix once it's sitting there. And it can make a big difference to the outcome in a case.
And you'd mentioned before, Judge, that sometimes the court might indicate that there could be a costs order made against them if certain conditions aren't met, and that there might be a letter sent to one party by the other, and that could be a formal letter of offer, which an unrepresented party might not appreciate the importance of. Do those letters typically have a certain title on them that might set an alarm bell off for an unrepresented litigant?
Well, they might say offer of settlement. They might not. They might contain the words "without prejudice, save as to costs." That should be a red rag to a bull. That's another. If they get a letter containing an offer, that's another time when they should be going to see somebody and getting some advice. So,
all right, thank you. And Joanna, from your perspective, how can self-representation go wrong, and what observations have you been able to make since starting this particular tact for your business in how clients have become overwhelmed in court or been disappointed with the appearance that they've made themselves?
Yeah, so one of the, and Judge mentioned this, is when parties really should see a lawyer and get some advice, and drafting affidavits, and when they do get an offer or they receive an offer or putting forward an offer, that's sort of the main request we get from self-represented litigants at the moment, is help with the documents and looking at the offers that, should they consider it and things. But I guess one of the big pitfalls I have seen with self-represented litigants is they try and argue their case at a mention, or they feel like they need to get everything out in the first mention, and they take up a lot of time in front of judges, just trying to put their case forward, and you sit there going, this is not the time, it's not the place. There's a time and place to run your case, and that's later. So that's also kind of trying to get that information out to people of when to say certain things and when not to say certain things. And also how to follow process as well. They may not have followed process. They don't actually understand the difference between a mention and an interim hearing or a trial. They think their first day in court is their big day in court. So they get all ready for that. So that's probably one of the biggest things I've seen, is people trying to run their case at those first days.
Interesting. Yes, of course. Well, to people watching, there are many mentions before you get to a trial date. The judge isn't sitting there waiting for you to argue their case at the drop of a hat. The judge wants to know that you're fully prepared and you have all your evidence ready to go, and that the other party has seen the evidence before even listing the matter for a hearing. So a tip there is try and find out what your court date is actually about and what will take place on that date. And Joanna, you've mentioned a few different kinds of dates there, a mention, an interim hearing, a trial. Is there a point at which, in your opinion, it would be no longer suitable for a party to appear unrepresented, and that they absolutely must obtain either legal advice or legal representation?
I mean, it's a hard question to answer, because I guess it does come down to the costs and things like that, whether it becomes impossible for them to continue. Some people have no choice. They have to do it themselves. But there are certain situations where I'd highly suggest obtaining a solicitor to represent you. And I think one of those would be at a final hearing, where there is cross-examination required. If people are going to pay for legal services or a solicitor or a legal team, that's the moment to bring them out, or to have them represent you. There's also situations such as when there's family violence. That's also a difficult one. And Judge mentioned a lot of these earlier in the session, when there are parties that we can't help with it, no amount of coaching or assistance or help will help them represent themselves. But if you're faced with somebody who has perhaps a personality disorder, drug and alcohol issues, where there is abuse or family violence, they are difficult situations to represent yourself. And there are other services out there, like community legal centres, that can assist in those circumstances if parties are falling within the gap of not being eligible for legal aid funding and not being able to afford a solicitor. There are some limited services out there that can assist. But I think it's really hard that, there's situations to say that there's situations where someone must have a lawyer, because sometimes it's just not possible to have a solicitor. Thank you. And Judge, from your perspective, is there a point at which people really need to have representation in court?
Well, there's certainly often a point when you wish they would, but for them, the fact that they can't afford it is still going to be uppermost in their mind. One thing that we haven't mentioned is one way that costs can be saved and that actually can give people representation at trial is a direct brief to a barrister. So they don't ever get a solicitor, or they don't have a solicitor throughout, but they find a barrister who'll accept a direct brief and appear for them in court. Because Joanna's right, the fact that people don't know how to cross-examine is a problem for them in court. I've seen so many people who will ask one or two questions, the other party will deny what the proposition they're putting, and they'll say, oh, well, he or she's never going to agree with me, so I'll just sit down. Barristers face that problem all the time. That's what they do for a living, and they have to get around it. And if people don't ask enough questions and don't challenge the evidence put up by the other party, that's another situation where they can affect their chances of success in their case.
Thank you, Judge. I understand that the government's doing quite a lot to protect victims of family violence in the courtroom. And in particular, Judge, are you aware of there being a provision for legal aid representation for people who might otherwise be required to cross-examine their own perpetrator of family violence?
It's not legal aid representation as such, but it is representation. So if certain criteria apply, so there's been a conviction for family violence or there's a current charge, if there's a family violence order current between the parties, or the court makes a decision that one party shouldn't be allowed to cross-examine the other, then people can qualify for legal representation free of charge. And that can apply not only to the alleged perpetrator, but to the alleged victim. So yes, there is that possibility there. That's only going to assist at the trial, though. It's not going to assist in the lead up to the hearing.
Yeah, but hopefully some help to those people who might otherwise have to confront their perpetrator of family violence.
That's right. Can I just mention another disadvantage that people, self-represented litigants, face in court, just very briefly, and that is that they're emotionally involved with the matter. So they're likely to get upset. They're likely to have their view of the matter skewed simply because they're emotionally involved in it. There are some things they can do to help themselves with that, though. One is to take somebody to court. Again, not a family member or a mate or a current partner who's going to get it there and make a nuisance of themselves in the back of the court, but somebody just for emotional support who might sit in the court with them. And at the trial, they can actually ask to have somebody sit at the bar table with them. It's called a Mackenzie friend. So that person can't talk for them, can't advocate for them, but they can sit next to them, give them that bit of comfort. They can help them keep their papers in order. They can give them a few quiet suggestions. And it might just give the self-represented litigant a chance to remain as calm as possible and to feel they've got somebody in their corner when they're running the case, which can make a difference.
Thanks for drawing that to our attention, Judge. Joanna, a question for you is about the children's contact centres. Now, these are places where parents can go to spend time with children under supervision. What advice would you give to community service providers, including, for example, a mediation or a children's contact service who was dealing with a family where one party does not have legal representation? Often these services try to remain neutral and impartial, but when a solicitor for one party asks for information about a children's contact, should the contact centre then share the same information with the unrepresented litigant so that both parties are treated equally?
That is that's a very difficult question. And I think it comes down to what information has been requested and how that information will be delivered. So there's a difference when, say, for example, a contact centre passes on information to a solicitor. The lawyer then has the responsibility of passing that on to their client. They assess how best to inform the client. Perhaps if the information is going to cause a flare-up of a conflict or some emotions, they can assess how best to deliver it and to mitigate any consequences. Any documents that are provided, they can also be very cautious in providing any documents to their client, making sure that the client's aware, don't go slandering anyone on Facebook or social media. So there's a big difference in telling a solicitor, because then the responsibility, I guess, goes to the solicitor in how to tell the client. With a self-represented litigant, it's what information, could this information flare up? How is it going to be delivered to the self-represented litigant? And who's going to tell that self-represented litigant not to post things all over social media, which happens so often these days. We all see it. So I think it really comes down to, I mean, ultimately, yes, in a sense, it should be shared to both the represented party and the self-represented litigant, but it would have to be handled on a case-by-case basis with a real analysis of how could this information actually impact on this person, what could be the consequences of the information, because things that happen at contact centres can be quite, I guess, sensitive natures, and the information could be quite sensitive. So it's difficult to kind of say yes or no. I think it just has to be assessed appropriately by the centre.
Yeah, and most importantly, whatever the professionals can do to protect the children's best interests, they will. That's at the forefront of all of these decisions. We're nearly at the end of our webinar. Before we can go to our final question, is there anything, Judge, from your perspective that we might have touched on that you wanted to discuss further?
I just want to make very clear that self-represented litigants can have successful outcomes in cases. I can think of dozens of cases over the years where the self-represented litigant has achieved the outcome they wanted. Grandparents who've kept the child with them instead of having the child go to the mother. A mother and a father in two separate cases that I did not long before I retired, who successfully opposed the child going back to the other party. And in both of those cases, it was contrary to the recommendation in the family report. I've had cases where the self-represented litigant has obtained a better outcome in a property case than the other party was ever willing to offer. So self-represented litigants aren't doomed to fail because they're self-represented. But the two things that stand out as meaning they're likely to be successful is probably, one, that the facts are on their side in the first place, and two, that they're polite. Every single case I can think of in which a self-represented litigant has prevailed, they've been calm, patient, and polite. So if I was to say anything to self-represented litigants, I would stress the importance of that.
Thank you, Judge. And to anybody watching, the courts are public places. My recommendation to you would be, before you go and self-represent, go and sit in a courtroom for a day or more and observe what goes on, in particular in family court proceedings. Observe those polite mannerisms that the barristers use at the bar table that judges just referred to, and try and replicate those yourself to the extent that you can. Joanna, do you have any further points to add from our discussion today so far?
No, but again, being polite in court is such a massive thing. I've seen people who just start arguing or yelling in court, and that won't get you very far for self-represented litigants. So definitely the polite comment.
All right. And look, we've all touched today on that family law matters can be often very heavy and very emotional. And I wanted to ask you each a fairly light-hearted question to wrap up our chat today. And that is, in the melodrama of the family court system, observing what you've done every day of your life, both as a barrister and at the bench judge, which actor would play you in the Hollywood recreation of your life?
Well, luckily you gave me a little bit of a chance to think about that, but it's not such a difficult question. I'll go with Judi Dench. Ah,
Judi Dench. There you go. I was thinking perhaps Meryl Streep, but there you go, Judi Dench.
Meryl Streep wouldn't be a bad choice, but no, Judi Dench came to mind.
Good answer, Judge. I can endorse that for you. And no doubt she'd do a more convincing Australian accent than Meryl Streep or one of the American actresses anyway. Joanna, for you, which actor would play you in the Hollywood recreation of your life?
This was a tough one for me, and I asked my team to help me out with it. But I would like Gal Gadot, the new Wonder Woman, to play me.
Not only a striking physical resemblance, but given that you are taking on something relatively new in the profession and doing it with bravado, and as the judge alluded to, at times putting your professional reputation at some level of risk, then Wonder Woman it is, Gal Gadot. Look, immense thanks from the Tamworth Family Law Pathways Network to you both for your time and valued expertise in offering your guidance so generously this morning. Thank you both so much, and goodbye.
It's a pleasure.
Thank you so much for having me.